I once believed in our Constitution of the United States. It has no safeguards for anyone anymore. Milton Mack was the judge that first heard my case. He told me that he didn't care, that it was my money, as well as my daughter. He started taking it. He says he wasn't giving me anything. I called him a liar and a thief with a robe on. These individuals have been using our monies from our settlement, which are in the millions, for their own personal use, while me and my daughter starved. For 2.5 years, the annuity company was making payments to the successors, appointed conservators, pertaining to our case, and keeping the monies for themselves, where I and my daughter did not even have food. Where every judge, from Milton Mack, Freddie Burton, Judge Kirkendall, Judge George from Macomb County that comes to Wayne County now to hear our case, has been stealing the monies. I don't have a car to this day to take myself to the doctor. I don't have medical insurance. They told me to let the Wayne County Probate Court steal our monies and for me to commit perjury and fraud and go to Social Security Administration and get money from them for us to live on while they steal it.
I was married to a Detroit police officer, and he became incredibly verbally and emotionally abusive to the point where he kicked me and my children out of our home with threats of violence. He became increasingly violent as far as emotional and verbal abuse goes. There was not physical abuse at the time. He did come to my home and raped me, where I was choked and held down. I reported it to a counselor. I then received no help. I tried. I went to an attorney who advised me not to report it, not to get a PPO. I went through a friend to a detective of the township I live in. They told me not to report it. I then saw another detective who said I had to go to IA in Clinton Township. When I met with that lieutenant, I was told the prosecutor would not take my case, that there wasn't enough evidence, yet he hadn't even met with me in person. I received no help from anyone in the law community, and I was the victim.
Well, you're supposed to represent the Constitution of America, and you're not doing it. So if you're not ready to represent the Constitution, you need to step down. We need to elect people that's going to represent the Constitution and protect the rights of all citizens. There are too many people are crying out in America, and it's time that the lawless in America stop.
So who do you call when your tax dollars the government is supposed to fund is instead used to support corporate criminals and their representative agents, such as attorneys? Who do you notify when law enforcement stops enforcing the law and instead applies the color of law to commit tyranny upon the people? What do you do when the courts become the settings where crimes are legitimized and covered up under pretense of providing due process while falsifying, modifying, and stealing what are supposed to be authenticated, complete, and permanent records? Who are these people in positions of trust who swear their solemn oaths to their duties of office and to protect and uphold the guarantees of our governments under the state and United States constitutions, who then turn right around and regularly violate these oaths, those duties, and the professional ethics behind those duties, and the due process rights of the very people who have entrusted them with such privilege of being public servants? Have these so-called officials, being law enforcement and judicial officers, lost touch with reality in knowing who really is in charge here? How about us, we the people? Have we too forgotten our true power as individuals and collectively to hold government criminals accountable to the people? Some of us have not forgotten our independence and our rights. We are the RICO Busters, ordinary people doing extraordinary things in the name of our families, our children and grandchildren, and our neighboring Americans. We are taking back our country, one investigative step at a time, by doing what the mainstream has long been failing to provide under the First Amendment as a truly free press, and by teaching what our government-run public schools have failed to provide in educating the last few generations of Americans, both indigenous and immigrants, with the first principles upon which this once great nation of the United States was originally founded. We are people just like you, shining a light on corporate and government racketeering. We are the RICO Busters. We are the people. And we're back. What does liberty mean to you? Uneducated citizenry is a vital requisite for our survival as a free people. So, is liberty freedom from responsibility or accountability, and the right to a free education and handouts from the government? Spoon-fed education from the government is not the answer. The NationalLibertyAlliance.org is in full swing on educating government and individuals alike on American history, the Constitution, our country's founding documents, and the power and remedy of common law grand juries. When the people fear the government, there is tyranny. When the government fears the people, there is liberty. Check it out. NationalLibertyAlliance.org. We begin this investigative RICO Busters documentary segment by acknowledging something that is very important. We understand that there will be some, if not many, who will say it is unfair, if not libelous, for RICO Busters journalists to put such an intense focus on one particular case, such as we are doing with Crystal Price's case. And while inferring that such conspiracies of crimes are being committed by the Trott & Trott law firm that is owned and managed by David Trott, and being committed by the Wayne County Sheriff, Benny Napoleon, and his special deputies, and being committed by Bernard Youngblood and those under his employ at the Register of Deeds office, and being committed by Kim Worthy and the assistant prosecutors under her employ, and being committed by the corporate persons of Bank of America and the Dykema law firm, and by the government-sponsored corporate enterprise of Freddie Mac. These people cannot even imagine how such a meeting of the criminal minds might even exist. The best way to address this skepticism is simply to underscore the fact that it has taken multiple segments of this RICO Busters series to present significant enough evidence to indict the corporate entity of Trott & Trott, the 34th District Court Judge Brian Oakley, and those aiding and abetting in the grand scheme to steal Crystal Price's home. Just as in real-life court prosecutions, RICO Busters must deliver such indictments by providing a proper context for the crimes to the court of public opinion. So to prove that the criminals had the intent, i.e. the means and the motivation, to carry out their crimes of misrepresentation and the numerous types of fraud, including but not limited to forgery, notary fraud, mail fraud, securities fraud, deed fraud, misleading advertising, undue debt collection, tax fraud, insurance fraud, fraud upon the court, and fraud upon the public by government officials choosing to look the other way and rejecting their solemn oaths to the state and the United States constitutions and their duties of office. In short, we need to answer the question of what is each person's interest and their accountability in the end result. That is as simple as the phrase, you gotta go along to get along. If people, elected or appointed, want to keep their jobs and to thrive financially in a depressed state and national economy, they capitulate. Remember, all that is necessary for the triumph of evil is that good men and women do nothing. Remember also that gross negligence, dereliction of duty, misfeasance, and malfeasance are crimes. This is one way in which we have implicated Kim Worthy in the office of the Wayne County Prosecutor, as well as the Wayne County Register of Deeds and the Deed Fraud Task Force, the Michigan Attorney General, and the U.S. attorneys and the federal judges operating in the Eastern District of Michigan and the Sixth Circuit Court of Appeals, who altogether have the task of uncovering and investigating these other types of fraud on behalf of the taxpayers. Instead, they contribute to it. We don't pay these government officials to look the other way while people are having their property, their sweat equity, and their dignity robbed from them. We elect and or pay them to act, responsibly and to have accountability for those actions. With that said, in getting back to Trot and Crystal Price's case, we will finish out this brief segment by looking closer at just one of the many parts Trot played in depriving Crystal Price of her due process rights through criminal fraud and a conspiracy to fraud to steal her escrow money and her home. Trot is a Michigan law firm based in the Detroit suburb of Farmington Hills. It doubles as a foreclosure mill with the so-called king of foreclosures, Trot owner David Trot, running for Congress against the grassroots favorite, an incumbent by the name of Carrie Benevolio. To give you, the audience, just a hint of what type of people David Trot and the Trot law firm employs to do their dirty work, which might be typical for slithering attorneys and judges now, at least here in Michigan anyway, take a look at this document that was created by Trot just this year, 2014. It is a quitclaim deed drafted by Trot attorney Kenneth Carell. Seems that mortgage fraud investigators Miami has done a little checking into this star player for Trot in the game of fraud against homeowners and upon Michigan and United States courts. MFI's Internet Notice warns the public that it has located at least 8 different ways that Carell's name has been crafted on foreclosure papers, affidavits, or other official legal documents. This investigative work deserves a closer look by this viewing audience. Who exactly is this person or these people that are using Kenneth Carell's name to execute the color of legal process against Michigan homeowners and who knows how many other unsuspecting people? Take a look. Is anyone to believe that all of these signatures are from the same person, Kenneth Carell, despite that all of these references point to actions taken by this Trot attorney? And while working on Trot's behalf, what else has Kenneth Carell been doing to contribute to the detrimental cause of the Countrywide scandal and the mortgage fraud leading to the too-big-to-fail 2008 bank bailout? It appears that Carell, as well as Trot, were up to their elbows in the mud surrounding this national Countrywide mortgage scandal, long before they had become the instrumental cause of this foreclosure scandal that Crystal Price has been facing. It's clear that from at least 2004, Kenneth Carell was the attorney and agent for Countrywide's dirty work. Before that, in 2002, he looks to have been signing his name apparently very differently while working for Home Loan Mortgage Trust 1999A, which I have tried to find today on the internet and see no evidence whatsoever of its existence. These corporations are always changing the color of their spots through buyouts, mergers, changing names like chameleons change their colors, and like con artists change their stories. In turn, it appears that Carell changed back to signing his name nearly the same in 2009 as he was signing in 2002. Except in 2009 he was signing as the vice president for MERS, the private corporation of the Mortgage Electronic Registration System, a holding of the MERS Corp Holding Incorporated. Now we need to understand something here that is so complicated the average homeowner, as well as the average securities investor, is oblivious. MERS was a corporate creation of the mortgage home loan giant Fannie Mae and Freddie Mac, along with several large banks in 1995, designed to save banks cost on foreclosures by circumventing their having to record with the county clerk's offices all of the dizzying changes these corporations make to take homeowners off guard, like they have been doing and continue to do with Crystal Price. According to Fraud Digest in 2011, Fannie Mae, like Freddie Mac, has relied on mortgage assignments prepared by its own lawyers, using titles of MERS officers, to prove ownership of mortgages. Fannie Mae and Freddie Mac undertake these actions to avoid filing foreclosures in its own name, to reduce bad press, counterclaims, and complaints that it frequently failed to work with homeowners to provide any meaningful modification alternatives to foreclosure. Frequently, these cases had involved Fannie-owned defaulted loans originated by Countrywide, and in cases like Crystal Price, involved Freddie Mac-owned defaulted loans originated by Bank of America N.A. And in Crystal's case, the loan was not even in default. In both cases, BAC Home Loan Servicing was the one to initiate the foreclosures in BAC's name. As explained on the blog website foreclosurehamlet.org, because court rules required that the foreclosure lawsuits be filed in the name of the entity that actually owned the mortgages, Fannie Mae, like Freddie Mac, pays to have two mortgage assignments prepared. First is an assignment to the servicing company by what is called a nominee, such as what MERS was for Countrywide Home Loans, and what BAC Home Loan Servicing was in Crystal Price's case. Second, after the servicing company successfully foreclosed, the mortgage would be assigned to Fannie Mae or Freddie Mac by the servicer. This way, Fannie Mae and Freddie Mac get the same results as if they had sued in their own name, but without much of the bad press and lawsuits coming back at them. The legal fees could then also be written off their government taxes simply as mortgage servicing fees. In this type of racketeering scheme, both assignments were usually assigned by employees of the law firm hired by Fannie or Freddie to pursue the foreclosure. On the first assignment, the law firm employees signed as officers of MERS, never disclosing to the courts or homeowners in foreclosure that they were actually working for Fannie or Freddie. Many of these MERS officer law firm employees are now under investigation by the state attorney generals investigating foreclosure fraud. By the way, Crystal has told me that she already has gone to the illustrious FBI stationed in Detroit in July of 2012, and all they did was to tell her that they would not do anything further, at least until after the courts finished screwing her too, and even then giving the inclination that they would still do nothing. This disposition of the FBI and the U.S. Attorneys and the U.S. Department of Justice's U.S. Office of Civil Rights is the reason why I tried suing them all in federal court while filing crime reports of racketeering and corruption all the way to the U.S. Attorney General Eric Holder, all to no avail, and with only further evidence of the corruption of the U.S. Federal District Court Judge Lawrence Zatkoff, who dismissed my case with prejudice, preventing me from taking my case higher to the U.S. Supreme Court. Getting back to Kenneth Carell, it appears that he is not the only trot and trot partner who is competing for the title of robo-signing champ. We can see that Ellen Kuhn is another partner in the law firm who also has numerous ways of signing her name on official legal documents that are being used in the home ownership and foreclosing process. Moreover, since we can see that she too signed as vice president of MERS, it behooves us to look a little bit closer at what might be motivating these trot and trot attorneys, Kuhn and Carell, to misrepresent themselves like this on numerous sworn and notarized assignments of mortgages. We'll also talk more about how Ellen Kuhn, Kenneth Carell, David Trott, Trott's wife Kathleen, and numerous others at the Trott and Trott law firm are paying the Michigan Attorney General and Governor to look the other way while they commit these fraudulent crimes. Since these two Trott and Trott partners are like two peas in a pod of racketeering, how about we talk about this example, which was a joint venture drafted by Kuhn and signed by Carell in 2009 as the vice president of MERS. We'll put this document in the context of an announcement published by the government-sponsored private enterprise of Fannie Mae in 2008 to clarify the ability of the servicer to, what I say, misrepresent the interest of Fannie Mae as holder of the mortgage and the promissory note in bankruptcy, foreclosure, and other types of legal proceedings. The 4-page notice published by Fannie Mae formalizes Fannie Mae's policy, a policy echoed by Freddie Mac, that it is all right to mislead homeowners, county deed offices, sheriff's departments, and the courts, causing them all to believe that the owner of the promissory note and the owner of the mortgage are two different entities. In fact, These policies of Fannie Mae and Freddie Mac are in blatant violation of the United States Code of Federal Regulations, and nobody in state or federal government is doing anything about it. Here is Title 12 of the Code of Federal Regulations, CFR, Section 226.39, covering mortgage transfer disclosures. For those of you who do not know what the Code of Federal Regulations is, in layman's terms, it is the administrative law or legally binding rule book for interpreting the underlying federal government codes so to ensure that these federal statutes are properly implemented and not otherwise violated. Title 12 pertains to banks and banking, and Chapter 2 pertains to the Federal Reserve System. Subchapter A deals with the Board of Governors at the Federal Reserve, and Part 226 deals with the Truth in Lending Act. CFR 226.39 then pertains to mortgage transfer disclosures. And if you read Section A1, you'll see that it states very clearly that, quote, a servicer of a mortgage loan shall not be treated as the owner of the obligation if the servicer holds title to the loan, or if the title is only assigned to the servicer, solely for the administrative convenience of the servicer in servicing the obligation, unquote. So in looking at this document again that was drafted by Trott & Trott attorney / MERS Vice President Ellen Kuhn, and signed by Trott & Trott attorney / MERS Vice President Kenneth Carell in 2009, we'll see that it is an assignment of mortgage, unquote. It says that for $1, the unnamed lender has sold all rights to MERS as the so-called, quote, nominee, unquote. This appears to follow the instructions set forth by Fannie Mae's published 2008 policy, which begins by clarifying that, quote, Fannie Mae at all times has possession of and is the holder of the mortgage note, unquote. It then moves on to explain that in cases such as foreclosure actions, Fannie Mae temporarily provides the servicer of the mortgage action with possession of the mortgage note, whenever the servicer is acting in their own name, but representing Fannie Mae's interest. In most such cases, however, the servicer only gets a copy of that mortgage note, a fake, not the original promissory note, which was the original contract between the original lender and the borrower, between the original bank and the homeowner. That is otherwise required for any trade of ownership. Fannie Mae's policy then goes on to say that at the conclusion of the servicer's what I call misrepresentation of Fannie Mae's interest in the foreclosure, the virtual possession of the copy or the fake note reverts automatically back to Fannie Mae, and Fannie Mae resumes being the holder, just as it was before and during the foreclosure. In other words, it's all a sham, and nobody is the wiser when the homeowner and the public are duped into believing that the so-called servicer, in this case MERS as the, quote, nominee, unquote, is actually purchasing ownership of anything for $1. Freddie Mac's policy guideline is similar to that of Fannie Mae. It too says, quote, the servicer must instruct the foreclosure attorney to process the foreclosure in the servicer's name, unquote. In the case of Kuhn and Carell's assignment of mortgage, it is in the name of MERS, the Mortgage Electronic Registration System, for which Ellen Kuhn and Kenneth Carell are both fraudulently the so-called vice presidents. In either case, the so-called servicer, or nominee, is instructed by Fannie Mae or Freddie Mac policies to process foreclosures in their own name, not in the name of Fannie Mae or Freddie Mac. This is blatantly deceptive. To help us to understand why, let's take a brief look at a 2010 foreclosure case ruling out of New York, in which the Corporate Bank of New York was listed as the plaintiff in a foreclosure case against what appears to be a group of private individuals. In that case, the judge's ruling pointed out that since 1988, the public had been put on notice that a previous court ruling had determined that a party cannot foreclose on a mortgage without physically having the actual title, and that a foreclosure cannot be brought by one who has no title to it, and that absent from the transfer of the actual debt, i.e. the one and only promissory note, the assignment of the mortgage is a nullity. It's basically bullshit. And that's what this document of Trott and Trott's, signed by Kuhn and Carell, is all about. It's nothing less than fully fraudulent, a blatant violation of 12 CFR Section 226.39 and the Truth in Lending Act. And in every foreclosure case that this setup is found, which is virtually every foreclosure case, this fraud upon the homeowners, upon the public, and upon the courts, when this document is submitted for a judgment of eviction once the house is stolen, there is clearly a conspiracy involved. In this case, it is the Trott and Trott lawyers, the servicers they represent, MERS, and ultimately the government-sponsored corporate enterprises of Fannie Mae and Freddie Mac. More importantly, and put in the context of the New York judge that recognized the 1988 case ruling just covered, the judges handling these foreclosure cases are part of that conspiracy to steal all of these homes. It's all by design of the Trott and Trott law firm, with their officers of the court, and our example being Kenneth Carell and Ellen Kuhn, by admission of their own signatures as vice presidents of MERS, setting the foundation for this criminal scheme. They are both acting as the contacted legal counsel for the actual owner of the mortgage and the promissory note, being either Fannie Mae or Freddie Mac, and while misleadingly impersonating national corporate officers having the falsely conveyed authority to otherwise be engaging in banking activities when they are in fact only lawyers and not accountants or bank managers. Carell and Kuhn and the Trott and Trott law firm thus appear, at least in my view, totally guilty of a felonious form of bank fraud.